morning, everyone. Today is October 14th, 2021, and welcome to the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong Motan in 2020. Every Thursday morning, Jean Lawler and I are so pleased to present another cutting-edge webinar on topics of interest to lawyers and mediators and negotiators worldwide. There's no charge for these great webinars. Rather, we ask you to contribute to a food bank if you like what you see. And over the last year and a half, our audiences have been so generous worldwide, helping to fight food insecurity. And it's one of my favorite parts of the webinar each week when we announce the running total so far. So with a virtual drum roll, Jean, let me turn it over to you. What's the running total?
Hey, thanks, Jeff. We're up to a whopping $191,150. So we're just shy of $9,000 to get to the $200,000 mark, and well over 2 million meals. So that's fantastic.
So we know that Professor Moffitt will want to go down in history as the answer to that great trivia question. Who was the speaker who put Will Work for Food over the $200,000 mark? So please, everybody, for that additional reason, if you're in a position to be generous with food banks, please do so. It really does a world of good. And with that, let's introduce Professor Michael Moffitt. Michael has been a member of the Oregon Law Faculty, University of Oregon, since 2001. He served as Dean of the University of Oregon Law School from 2011 through 2017. He has published more than 24 scholarly articles on mediation, negotiation, and civil procedure. He co-edited the Handbook of Dispute Resolution, an award-winning compilation of 31 original chapters by leading scholars and practitioners in the field. Actually, if you look at Michael's website, this is not the only award he's won. He has won every award for which he has been eligible. It's fantastic. He's also co-authored the innovative student-focused book, Dispute Resolution, Examples and Explanations. His most recent article, Settlement Malpractice, which will be the gist of our presentation today, was published in the University of Chicago Law Review and has won the prize for Best Article of the Year by both the Association of American Law Schools section on professional responsibility and the section on dispute resolution. Michael and I both have had important relationships with one of our heroes, the late Professor Frank Sander of Harvard Law School. And indeed, Michael and I met in 2018 at the memorial service for Professor Sander that was held in Cambridge. And we hit it off, and we promised each other that we would find some things on which we could collaborate. And this, Michael, I hope will be just the first of many such opportunities over the years to come. We're so glad you're here to tell us about settlement malpractice. Please tell us a little bit about the food bank to which you'd like us to direct our contributions if we're able to do so, and then your presentation. Our friend Michael Moffitt, the floor is yours.
Thank you so much, Jeff, and thank you so much to all of you, especially those of you for whom this is a super early webinar. I am as well caffeinated as I responsibly should be, but I invite you to join me in that. The food bank to which I have donated for years is called Food for Lane County. It is our local food bank, and I can probably somehow put the link in the chat, but thank you so much to all of you who've put this together. Food insecurity is my primary passion cause, and so the confluence is outstanding. So my presentation today has a much better title thanks to Jeff's work. My original title was very scholarly, and it was not a good title. This is a good title. Here, I guess I feel like I should say at the beginning, I really love negotiated settlements. I love mediation. And I feel like I should say that at the beginning because I'm going to spend the rest of this hour talking about and answering questions about things that go wrong. And there's a risk that I will sound grouchy or unsupportive. And in fact, I am the opposite. I have bet my professional career on the importance and integrity of consensual resolutions and the people who work in it. And I think there is beautiful work being done around the country in these spheres every single day. But the thing that led me into this was the realization that there are conservatively tens of thousands of people mediating every year, and there are hundreds of thousands of lawyers advising clients about settlement every year. And it strains credulity to imagine that none of these human beings ever make mistakes as they are doing those things. That just seems impossible to me. Instead, I think it is reasonable to assume that sometimes, somewhere out there, lawyers and or mediators make some regrettable decisions for good, bad, or other reasons. But it occurred to me that in the decades I had been studying ADR in one form or another, and as a practitioner attending webinars, less cool than this one, but webinars nonetheless, pretty much all I ever heard were heroic stories. They were mediators doing this great work, settling this hard case, or they were attorneys coming up with this really cool way to structure this deal in a way that made resolution possible where nobody thought it would. They were all good stories that with happy endings. And that's in stark contrast with what we typically do in law school, right? Most of law school, we study stories that go wrong. We study contracts that got broken. We study torts that happened, or property that was damaged, or crimes that were committed, right? These are all unhappy stories in law school. I don't think it's because there's a particular pathology in law schools. I think it is not just rubbernecking. It's we find these stories of things going wrong instructive, educative. They're cautionary tales. And so I went out looking for the cautionary tales, for the stories of things when things went wrong. And the headline, just so you know where I'm going with this, is I tried to, I guess I would invite you to join me in the thought experiment I did. I tried to imagine the worst things I could possibly think a mediator or a lawyer negotiator might do. I mean, get creative. What's the worst you can imagine them doing? And then I just tried to figure out, well, why doesn't that happen? And the headline is, for those of you who just want to know, like, what's the headline? Am I at risk? All of the empirical evidence, and I can say more about what I'm basing this on, but all of the evidence suggests that you are very unlikely to get sued successfully for malpractice in your role as a lawyer advisor, as a negotiator, or as a mediator. And I'll say more about why that is, and then maybe how we should feel about it. It's not that there are none. There are cases out there, but they are rare enough that I am skeptical that they represent all of the times when people screwed up. And I am skeptical that the low rate of malpractice claims will persist indefinitely for some reasons that I'll get to here in just a little bit. All right, so let me start with, and I'm going to divide a little bit. There are two different buckets of malpractice that I have looked at. One is legal malpractice related to settlement, and the second is specific to mediators. I'm going to start with the lawyer negotiator side first, and then come back to the mediator side, because I think that sequence, I think that makes more sense. I studied a lot of cases. I studied about 24,000 cases to try to come up with the following. And here's as an empirical matter, lawyers get sued for malpractice many times in the year, not each lawyer, but over the country. If you look at the country, there are thousands of malpractice claims filed against lawyers every year. What my research assistants and I did was we went through and we coded all of the malpractice claims for about a decade in, it was 11 or 12 different states, chosen not entirely randomly, chosen to try to represent the range of different, some model codes, some model rules, some states with some different tort rules, big states, small states, and whatever. So of those, there were 16,000 cases that we coded. And I'm not saying that lawyers are sued too often or too rarely, But if you look at the number of cases filed against lawyers, and then you ask what percentage of those were lawsuits having something to do with settlement conduct, settlement advice, that sort of thing, it's just under 1%. Lawyers get sued for a lot of things, but not things related to settlement by and large. So then I looked at bar complaints, right? Because that's a different angle in on the prospect of unhappy clients. I looked at about 8,000 bar complaints, again, filed in a range of states over about a decade. And in that case, only about 1.5% of the complaints filed against lawyers had anything to do with settlement. So just as an empirical matter, it's quite uncommon. Even with my broad definition of what is settlement related, anything that was even vaguely about settlements, I included in these data, and they just don't happen very often. There are some cases, and I'll talk about 3 of them here in a second. But what I want to do is take a minute and do a little bit of theoretical explanation, my explanation for why those numbers are so small. I'm not making a normative argument that they should be bigger. I'm just asking the descriptive question, why is it so uncommon that lawyers get sued for settlement related things? Since lawyers get sued for a lot of things, are we just atypically awesome at all things settlement, or is something else going on? And I think something else is going on. And I think what it has to do with is the assumptions baked into our legal malpractice standards assume a vision of lawyer as litigator, rather than a vision of lawyer as negotiator, lawyer as settler. So let me say what I mean by that. If you think about legal malpractice, it has 3 assumptions baked into it. 1, it assumes that it is proper to give judgmental deference to a lawyer's decision. And that makes really good sense, right? We don't want to second guess, why did this lawyer call this witness before that witness? Why did this lawyer ask this question this way as opposed to that way? It's just way too subjective, way too many shenanigan opportunities. So we give huge deference to the litigation decisions that a lawyer makes, right? Even up to and including things like the theory of the case. We are not going to try to unring that bell and figure out what would have happened if the lawyer had pursued some other theory of the case. We're not going to do it. And I think that makes sense. The second of the assumptions baked into our legal malpractice system suggests that any mistake a lawyer makes will be reflected in the client's the client's litigation outcome, right? If the lawyer messes up, the client becomes more likely to lose the case or gets a worse number of dollars as the outcome of the case, right? So lawyer mistakes are reflected in trial outcomes. And again, if what we're talking about is litigation malpractice, that assumption makes really good sense. And then the third of the assumptions baked into our legal malpractice system is that the appropriate measure of damages for a lawyer who has screwed up is the difference between what the court actually awarded in the case where the lawyer made the mistake and what the court would have awarded in a case with a minimally competent lawyer, right? That gap is how we define the damages. The challenge with that is that assumes that clients' interests and injuries are bounded by the remedial powers of the court, right? We can only compensate that which a court would have awarded. And that stands in stark or tension with a lot of what we know about settlement and the way settlement happens. So these, I think, as a theoretical matter, provide some decent explanation for why courts have handled legal malpractice claims the way they have in a settlement context. What I thought I would do is take a few minutes and just describe 3 cases. And I want to be clear about the cases that I chose. They are not the sort of, I did not cherry pick the most entertainingly awful cases. We can talk about that if you want. I chose the hard cases, 3 cases that are challenging to think through, that I think if in combination, these three cases will give a sense of why the landscape looks the way it does. And so the first of these cases is one in which the client was a defendant in a piece of commercial litigation. The plaintiffs made an offer to the client's lawyer to settle the case if the client would pay $450,000 and relinquish control of a contested company. There were some details. The lawyer never told the client about the offer, just never told them. So the case went to trial, and the client lost very badly on terms far worse than this settlement offer was. The client learned of the offer after the fact and sued the lawyer for malpractice. Now, I think this would be an easy-ish case if the client in deposition had said, quote, "Had I known about the offer, I would have taken it." Close quote. I mean, that still is kind of a hard case because it's self-serving testimony, but we have cross-examination for that. And right, we ask fact finders to unpack things like that all the time. In fact, what the client said in deposition was, if I had known about the offer, I don't know. I mean, I definitely would have taken it as a sign that they were willing to negotiate. So I would have instructed my lawyers to try to go get something even better, which is a real world matter, is a very reasonable thing for a client to say. But it caused the lawsuit here to be dismissed summarily. Right? Because here we had, in this case, it was the Texas Supreme Court a couple of years ago. They said, no, that's just not good enough. And this leads to a couple of questions, a couple of reasons I think this case is a hard one. One having to do with the realities of iteratedly strategic things like negotiation. Is it reasonable to ask a client the binary question, would you have accepted that? It's a fiction of our tort system that we make them do that, but as a real world matter, I'm not sure that that's how it works. It also raises the question about whether we can speculate about what would have happened in a negotiation that never happened, right? What would have happened in this settlement talk had the client known about it, had the client engaged in it? We don't know. How willing should we be as a system, as a tort system, to speculate about that? I don't know. And then, and this is a theme I'm going to come back to, should we attach any value to the fact that this client was deprived of choice? Right? If you look at legal ethics codes, the model code, the model rules, whatever your states are, every one I've ever seen talks at great length about valuing client self-determination or autonomy or agency, right? Clients get to choose is baked into our, but our tort system doesn't think that that choice is worth anything because clients can't get compensated for it. So it's a hard case. A second hard case. This one came up in the context of divorce. The client in this case, the client was the wife in a heterosexual marriage. Wife and husband were getting divorced. Wife hired a lawyer to negotiate a settlement. The lawyer negotiated the terms of a divorce settlement, presented it to the client. Client said fine. There's some argument about whether the client said fine, but for our purposes, client said fine. Client later learns, one wonders from whom, but later learns that the deal was, quote, ridiculously inadequate. So the client fires her original lawyer and hires two lawyers. One to represent her in a renegotiated matrimonial settlement, and the second to file a legal malpractice claim against the first lawyer. I'm most interested in the second. The new lawyer charged with negotiating a better deal did negotiate a slightly better deal, but not a fabulous deal by most accounts. And that's quite reasonable, right? Because there was already this original deal, and the anchoring effect has effects. And so, you know, you can't unring the bell. And so they did wind up settling the case. The malpractice action against the original lawyer, who was part of getting this, quote, ridiculously inadequate settlement, went forward, but not until after the divorce was finalized. The colloquy in court for the finalization of the divorce looked, I think, pretty standard, except there was one part in which the court said to the client, all right, you're telling me you've discussed this settlement with your attorney and you think it's a fair compromise. Is that accurate? The client says yes. The court says, you probably feel you're not getting as much as you want. I'm sure your husband feels he's paying more than he should. If that's true, it's probably a test of a fair compromise. I don't know about that logic, but okay. I ask you one more time, are you accepting this compromise voluntarily? The client says yes. The court says, all right. Then her lawyer stands up and says, all right, as I've explained to you, in the malpractice action that I'll place on the record, it's your understanding that entering into this divorce settlement agreement will not prejudice you in that case. Is that correct? And the client says, right. And the lawyer continues and says, so it's my understanding, or it's your understanding that by entering into this agreement, you're still preserving any and all claims against your former attorney, right? And she says, right. So the court says, fine, and rubber stamps approves the terms of the divorce. And the original lawyer in the malpractice action immediately files a motion to dismiss the malpractice claim. And the Connecticut Bar Association supports this. I'm sorry, the New Jersey Bar Association supports this stance, and the New Jersey Supreme Court agrees that this malpractice action should be dismissed. And the logic goes back to this colloquy because, says the New Jersey Supreme Court, this client said under oath that this compromise was fair. How could there be an injury if the outcome was fair? Is a client entitled to more than fair? She said this was fair. There must be no injury, therefore the legal malpractice case is dismissed. Raises some questions about what meaning we should make out of subsequent settlements. Pennsylvania has a very extreme vision of what meaning we should make out of settlements. New Jersey is more in the mainstream of the U.S., but it's a thing. Last of the three cases is this was a medical malpractice action against a doctor who was the client. The doctor's lawyer was negotiating with the Connecticut Department of Health and negotiated a settlement in which the doctor would pay, I think it was $2,500 and no admission of guilt, and it would be done. And the lawyer presented this to the client, and the client, the doctor, said, look, I have practices principally outside of Connecticut. If I agree to this, will it have any impact on my ability to practice? And the lawyer said it'll have, quote, essentially no import. So the client said, fine, $2,500, this is easy, paid the fine. And California immediately imposed reciprocal discipline and restricted the doctor from practice in the state of California, where most of his business was. So the client sued the lawyer for malpractice, saying, hey, you told me this would have no impact. Fast forward, the client loses again. If you're sensing a theme, you are sensing it accurately. In this case, the client lost because, according to the federal court in the District of Connecticut, if the doctor had gone forward with this action, the doctor could not prove to a preponderance of the evidence that the doctor would have won in front of the Connecticut Department of Health. So, says the federal court in Connecticut, the doctor got what the doctor was going to get anyway. They were going to lose their license in California anyway, so there's no harm here. Now, for those of you who do any torts practice, this should smell of the loss of chance doctrine stuff. Here we had somebody who Well, basically, the way this law works is if you have a 1% chance of winning or a 48% chance of winning, under this line of logic, you cannot be the victim of legal malpractice because you would have, in air quotes, lost anyway. And it treats as co-equal two very different circumstances that, and in a way that I find troubling, but there it is. And again, I'll note what this winds up doing is placing no value on the client choice, right? This doctor had it was a he, I'm pretty sure, his choice taken away from him, right? Whether to contest this in Connecticut or whether to settle, he had it taken away from him, at least his informed choice, right? Because his lawyer told him something that was inaccurate. And so as to lawyering, where I'm going with this is all of these assumptions in our legal ethics and our legal malpractice, our tort regime that imagine lawyers as litigator really emphasize things that are not as true for those of us who work in settlement. Negotiation decisions surely should have the same kind of legal deference as litigation decisions, right? Whether to make this offer or that offer, whether to meet in my office or your office, whether to meet this Tuesday or next Tuesday. These are all strategically interactive decisions in the same way that that litigation is strategically interactive. And so I can imagine why we would do legal deference as to those decisions. I can't imagine, though, why it is that we grant such deference to the advice lawyers give about the implications of settlements, about the prospects at trial, right? There are other aspects of being a settlement lawyer that are not encompassed by this vision of strategically interactive. It also ignores the reality that that there's a difference between the litigation value of a case and the settlement value of a case. And I don't need to tell this audience about the implications of that. And finally, as I said, it ignores client choice and this prospect for non-zero sum outcomes and things like that. So from a lawyering perspective, the headline is, as a practical matter, our system protects lawyers a lot. One might wonder whether maybe too much, but certainly it protects lawyers a lot for their work in settlement. But if you go back to my question of like, what keeps people from doing bad work? How do we prevent this? There are basically 4 ways that we prevent, just as a system. There are basically 4 ways that we try to assure that clients get good quality, whether it's from lawyers or mediators. And lawyers are probably the easier ones to explain. We have some front-end mechanisms and some back-end mechanisms. We have some public and some private, and it makes a nice 2x2 grid, which law professors love. And so, for example, one way to assure quality among the bar is front-end government efforts. These would be things like the bar exam, right? You need a license to practice law, and in theory, the getting of the bar exam is protecting consumers from riffraff who would otherwise do who knows what. Number 2, there are front-end private consumer-based mechanisms, right? So for example, there is a market out there. There are reputations out there. You hire this law firm because they have a snazzy reputation and you think it's a proxy for quality. And maybe that's not a bad assumption. I mean, it is what it is. Number 3, there are some back-end mechanisms that the government can take. If you are a super bad lawyer, the government can super take away your bar license, right? It's a thing we can do. And the idea is we are protecting consumers by taking away the rotten apples. And then number 4, there are back-end private. If you get hurt by legal malpractice, you can sue the lawyer, which can have educative and compensatory impact, right? So that this as a basic structure represents largely the universe of ways in which we try to assure the quality of services. Now let me take a turn quickly to mediators and note how this system, this 4-part system that works for lawyers and doctors and others, has trouble in a mediation context. So first, front-end public, the idea here is licensure, right? Barriers to entry. But you know, we don't operate in a licensed profession. We didn't have to take a bar exam to be a mediator. Now, some of us took a bar exam to be a lawyer and then needed to be a lawyer to be certain kinds of mediators, but there isn't a mediator exam as such. There are places that have tinkered around with this. There are sources of cases that require certain kinds of credentials that we might see as analogous, but there is no monopoly on the asking of open-ended questions, right? You can't get sued for the unauthorized creative solving of problems in a way that you can for the unauthorized practice of law, the unauthorized practice of medicine. There's also a schmediation problem, which is an article, I wrote an article called Schmediation and the Dimensions of Definition. Whatever definition you have of mediation, it's entirely possible that if you had a requirement that you need a license to be a mediator, you would just immediately see a bunch of people printing out business cards that don't say mediator, they say schmediator, or they say facilitator, or convener, or whatever it might be, right? There's a thesaurus out there that gets in the way of number one, but that's okay. We have 3 more to go. What about front-end consumer, right? Markets and reputations. And those of us who make all or part of our living as mediators, and I used to pay my bills by doing this in part, we might be tempted to say, well, the market works great. Consumers found me. Fair, and with no disrespect to the people on this Zoom webinar, I think we would all say the reputational market for mediators is challenging. It's hard to know who the good mediators are, in part because of confidentiality, in part because we don't have the same, I mean, who is a good accountant? I don't know. Who is a good accounting firm? There I might have an idea. You don't have the same aggregated mediation model, right? So you don't have as many market proxies. It's just hard. It's hard to know who a good mediator is from who is just good at self-promotion. And so I'm not confident that we should put all our eggs in the number 2 basket. So that gets us to number 3. What about after the fact? Could the government just go after the bad ones? I mean, maybe, except there are 2 problems with that. One, what's the government going to take away? If they didn't give you a license to begin with, they can't take away your license if you turn out to be lousy. And the second of the challenges, on what basis would they be taking away your license? There are some standards and codes out there that many mediators say they are going to adhere to. It's really hard. And I've studied a bunch of the complaints against mediators. It's really hard to make them stick. Which leads to number 4, which is, well, what if the clients just sue the mediators that they're unhappy with? And this does happen, right? Clients will sue mediators. And the idea is good, right? Let them sue and then get compensated. And if you're just a serially bad mediator, you'll get out of the practice because you keep getting sued for it. That's the idea. It doesn't happen very often. And when it does, the consumers almost always lose because they can't demonstrate that the mediator had a duty, that the mediator breached a duty, that the duty caused any injury, that they can't quantify what the injury is. And in many jurisdictions, they have immunity. So clients lose these cases a huge percentage of the time. And that winds up being a challenge. And so the last, and I will stop here, the last of my observations is that these 4 sort of ways to assure quality are not at the moment robustly engaging in the way that we see them engaging in other practices in other professions. I don't think this situation will persist. I think there will come a time when it is more commonplace. I don't know exactly how that's going to happen, but I will observe that 60 years ago, 70 years ago, medical malpractice insurance was essentially unavailable. It was a rider on your homeowner's insurance oftentimes, and it cost a few bucks. That is in stark contrast with medical malpractice today. Similarly, legal malpractice looks very different today than it did 40 years ago. Will our settlement practices look different from a liability landscape perspective? I think they will. Whether it'll be a combination of one of these, four of these things, I'm not sure, but I'm not sure what else it would be. So let me pause there, and because I can tell stories and go on more, but that's about half an hour's worth of the big picture on it. Let me just pause there and ask for questions, for follow-up. I'm happy to say a lot more about this. And again, I just want to repeat what I said at the beginning. I love settlement. I love mediation. This is not me being grouchy at us or our colleagues. It is a professional cautionary question I am raising. And so let me stop there and see if there are questions or comments.
So, Michael, thank you. That was a really engaging and stimulating conversation of these important points. Let me make an observation and ask you how these issues of mediator liability interact with our standards of mediation confidentiality.
Yeah.
Because the confidentiality statute, at least in California and in some other places, acts as a de facto mediator immunity statute because there's no admissible evidence of anything that happened in connection with the mediation, which someone can use to prove whether the mediator committed malpractice or not. And it seems to me that mediators are too interested in having this kind of immunity. My view has always been, in fact, that if we care about our clients, the people with whom we're working, we should want there to be some kind of liability mechanism, because as a matter of morality, if you know you've done something that has caused financial harm to the people in your mediation, improperly disclosed confidential information, or negligently drafted a settlement agreement exposing somebody to adverse tax consequences, something like that, and you have indeed paid the modest premium that we pay to our malpractice carriers for errors and omissions insurance, the only one who really benefits from mediator immunity is the malpractice carrier who has collected a premium and does not have to pay on a righteous claim. So I just know, for me personally, if I ever did something that was below the standard of care and that actually caused somebody financial damage, I would want there to be a mechanism for those people to be compensated. Otherwise, I don't know how I could put my head on the pillow at night and go to sleep. What is your thought?
That is, I was going to say that's such a good question. That's such a good 5 questions, Jeff. As a normative matter, I think I land in a very similar place to you about where, to the extent there is a should in air quotes, I think my should and your should align tightly. As a descriptive matter, I think that there are at least 2 different things going on beyond crass self-protectiveness. Not sure that's a word. One is that that only a percentage of mediator misconduct is in fact confined to the mediation room. Right? If you think about, I wrote an article a good while ago called 10 Ways to Get Sued, a guide for mediators. Just thinking, if you want to get sued, here's how to get sued. And I said, here are 10 ways you can get sued. Some of those things take place in the context of a mediation room in a way that would be covered by the confidentiality statutes you're describing. So things like you said, providing bad drafting advice, or breaching internal confidentiality. This client told me this thing and I wasn't supposed to tell the other, or advising about legal entitlements and things like that, right? That it'd be inside. some mediator misconduct is not within the mediation room. Things like failure to disclose conflicts of interest, things like false advertisement, things like, I mean, there are some that would not, the confidentiality statutes would not shield a mediator from. And so I just want to name that as part of the landscape. Only some of the things that mediators screw up are inside the mediation room. My understanding of the policy argument favoring this, what amounts to a bar on claims against mediators in states that have that sort of a protection, like California, is that it is not about mediator liability. As a policy matter, I think what the legislatures and the courts have been concerned about are after the fact shenanigans, seeking not to find ways to reveal bad actions by mediators, but rather, I think the concern is that if we let people sue mediators and that becomes the way in to those settlement conversations, what we're destroying is settlement confidentiality writ large, not just the question of mediator conduct. I'm not sure the UMA got this right either, by the way, but again, my opinion on this. It depends who you give the privilege to, doesn't it? If you give the privilege to the clients and not the mediator, then that concern largely is addressed. But the way a lot of states have done it is they've also given mediators the privilege and therefore the ability to shield themselves from testimony about those things. I think a way to try to get at the interest that you're talking about, Jeff, would be to keep the privilege with the clients, but strip it from the mediator, so that if you had a case in which the clients agreed about going forward against the mediator, then I think that the policy argument gets a lot harder to say we shouldn't even do that. It doesn't get all the way where you're going, because strategically, I imagine the people on the other side of the V might oppose it. But I do think that is a piece of what is going on here from a policy perspective, is where we're fearful of unraveling or shining a light on the negotiations, not just the mediations. I'm not sure that fear is justified, at least at the order of magnitude that we have it, but I think that's part of what's going on.
I think the proof might be in the pudding of what's actually happened in the UMA states.
Yeah.
That indeed, there does not seem, at least as far as I can tell, does not seem to have been a floodgate. Let me ask one more question, Michael, and then we'll open it up to others.
Yeah.
And that is that in the business and commercial area where I mediate and Gene mediates and many others on this call mediate, everybody's all lawyered up, and there's lawyers sitting they're in every nook and cranny of the mediation suite. There's another whole domain of mediation, some family law, in New York they call it matrimonial or divorces, where huge numbers of parties are unrepresented by lawyers. And they're in mediation because they can't afford lawyers. That's just the reality of it. And mediators are, as far as I can see, going dangerously close and perhaps crossing the line into law practice, drafting documents to be presented to courts, albeit not with the mediator's signature, giving people what can only be described as legal advice because they have no one else there to give them legal advice as to what can be some pretty complicated legal issues. What about the malpractice risks, both as a policy matter and practical matter, for people dealing with unrepresented parties? What are your thoughts?
You've identified where the rubber meets the road. For as a statistical matter, that is where most mediations are happening. That context, it's not, there aren't as many zeros involved in the amount in dispute, but the numbers of cases are far more like that. I used to give presentations along these lines to trial lawyer associations. And my headline in that was, because a lot of them imagined themselves at some point going and being mediators after they stop being litigators, not unreasonably maybe. And my advice to them was that the easiest way to commit mediator malpractice is to commit legal malpractice. That really there is a much more robust opportunity for demonstrably awful service, compensably awful service, if you think about it in terms of legal malpractice. And the two conspicuous examples of that are engaging in the practice of law in a state in which you are not licensed to do so, or engaging in the practice of law badly, right? Giving either because you're not handling the conflicts problem correctly, or because the substance of your advice is terrible. And there are lots of examples of that. They are, to my mind, frustratingly still devoid of compensation in most contexts, but it is a place where we're seeing real, the volume of complaints against mediators, not just lawyer mediators, but mediators, huge percentage of them sound in legal malpractice. You told me X was a good idea. It is in fact a terrible idea, a demonstrably legally terrible idea to structure this deal this way. Or you told me that going to court would look like this. In fact, it looks nothing like that, and I had no way to know. That captures, I'm going to make up a number just based on Gestalt, 80% of the complaints that I have read about against lawyer mediators, or mediators who sounded like lawyers. You've named exactly where the struggle is. For decades, mediation programs have been trying to find a way to provide legal information to unrepresented clients without lapsing into the practice of law. We've not figured that out yet. I mean, and I'm not saying I haven't figured it out and the world hasn't. I haven't figured it out either. It is very hard to know how much information one provides unrepresented clients before one is engaged in the practice of law. Some states have taken a categorical approach and said, no, that's not the practice of law. Essentially, no matter what you do, as long as you call it mediating. I think that's a problematic stance. But fine-tuned, it's hard to know how to handle this. And so that's a very law professor-y answer of saying, I don't know, it's a hard question. It's a really hard question. And we're seeing it live on the ground in every state that I've studied.
Well, thanks. Now I don't feel so bad about not having an answer myself. So let's open it up to others. We've got about 10 minutes left. Gene, do you want to, I don't know if you want to take first crack, but if anybody, Gene or anybody else would just like to unmute yourself, if you're comfortable doing that and asking a question or typing it into the chat, simply
I see Ross has his electronic hand up.
Okay, okay, Ross, as they say on Jeopardy, please make sure your question is in the form of a question.
So, thank you. So Ross Cartez, practicing in New York, chair of the New York State Bar Association's dispute resolution section. One thing that's asked a lot is about the insurance policies that people have, as litigators. And, I'm curious generally, and I know you can't tell me without reading an insurance policy, generally, is my insurance policy, my legal malpractice insurance policy going to cover me for claims as a mediator?
I don't know. I mean, there's the responsible answer. If I were in the position of wondering that. Last time I looked, a mediator malpractice rider on an insurance policy cost like a cappuccino. It is breathtakingly cheap, except when you look at the data of how much payout the insurance companies are actually making. And I don't know, I don't have current data, but some time ago I got information from the underwriters. Turns out there's only one company that underwrote essentially all mediator malpractice insurance policies in the entire country. They're not paying anything out. So a cappuccino is a great deal from their perspective. I would probably not count on it covering it. Again, without reading yours, I don't know, but I wouldn't.
Particularly because of the
that,
cost.
like I fly without a net because I've done the research and I think it's vanishingly unlikely that I will be sued successfully. But really the practicing mediators that I know who are in that posture have made the decision to spend the cappuccino for the rider, essentially for defense coverage costs, not for the prospect of payouts.
Yes, and the additional coverage that you get under that for an extra cappuccino a month is discovery subpoena coverage that will provide you a defense lawyer to resist production of testimony or documents if you're ever subpoenaed by anybody which is not really a claim of malpractice, but it's still a situation where you need a lawyer. Other questions, please.
Does that help, Ross?
Here, I have one thing to add to that. It's not really a plug, it's just information here, but if you are an attorney in America or Canada, I believe, the Association of Attorney Mediators carries a malpractice policy, a group malpractice policy for mediators, arbitrators, and hearing officers that is included with your membership fee, which is only $275 a year. And the insurance provides defense separately from indemnity money.
That's great. And one cautionary note that I'll just name here, one of the potential costs for those of you who are serial joiners of associations, if you just love saying you're a member of this, that, and the other association, is that in a generic malpractice action against a mediator, one of the very hard things to demonstrate is a breach of a duty. And in fact, it is the existence of a duty. What duty does a mediator owe his or her clients? Turns out to be really hard to pin down in most cases. But if you are a member of an organization that has promulgated a set of standards, one can make the argument that by advertising yourself as a member of that organization, you are implicitly adopting those standards, and bang, now you have a duty that I can try to demonstrate you breached. I'm not saying don't join, I'm saying if you were the most cautiously minded and you're at risk of being sued, it's a consideration.
And of course, they're not all consistent with each other.
No, they're not.
So we have 6 minutes left, Michael. So let me ask you an easy question. You talk about duties, and the question is to whom the duty is owed. And you and I probably took the same professional responsibility course at Harvard Law School back in those days. And the first thing we are taught is that duties are owed only to clients, and that no client, no duty, right? So I've had many interesting colloquies with other mediators. Who is the client? And I have my views on that. I'm interested in yours. Who are the mediator's clients?
Even for lawyers, the idea that there is no client, no duty is overstated, even if directionally correct, right? Lawyers have a duty to the courts that actually trumps that of their duty to clients. You can't lie to a tribunal, even if it helps your client, because there is this overarching duty. I don't know if mediators have any parallel overarching duty. I am most intrigued by periodically there have in professional responsibility circles been notions of the idea of lawyer for the context. And the analogy is to, and this is an imperfect analogy,
That's
but
the Brandeis concept,
Yeah.
right? The lawyer for
Yeah.
the situation. Yes.
and we see examples of that in other professions, right? There are couples therapists who would say, my client is not you or your spouse, my client is the relationship, right? Or some conception like that. I think that there are ethically defensible, really good ways that a mediator could contractually or otherwise enter into an arrangement like that with her clients, that the duties could be structured in that way. I am not confident that a state bar discipline committee would share my view of that. That is, I would sleep well at night. I'm not sure that the legal profession, to the extent we're talking about lawyer mediators, because the cross-professional practice is what's, I think, more complicated here than the non-lawyer mediator. I think that the ability to structure a set of duties in a posture different than a lawyer-client relationship is not problematic. It's just problematic in a context in which you also have legal malpractice concerns, because I don't think the model rules or model code do a very good job of addressing some of those contexts. And I think the place that I would look for the most guidance on that would be the collaborative law states that have tried to figure out a way to make collaborative law in the family context consistent with this notion of neither dual representation nor single representation. I think they're the folks who've done the most careful thinking about that, and that's where I'd look.
Okay, we've got one or two, thank you for that. We've got 1 or 2 minutes left. Any last questions from anyone? Burning issues in your minds? Well, with that, Michael, I'm going to
Say one thing, if I might, Jeff.
Jean, go ahead, please.
There was a question a couple of questions in the chat earlier about the slides, if they could be made available.
Oh, sure.
Would that be okay? How would you want to do that?
I have no idea how to do that, but we will figure it out. If you email me, I am happy to send them. There may be a more efficient way to do that, but barring that, at least for right now, there's my email address at the bottom. And if you need a sleep aid, I recommend these 2 articles.
Okay, thank you.
Thank you. Michael, this was just terrific. Thank you. Thank you so much. I'm quite confident that Food for Lane County was going to get a lot of contributions. That's www.foodforlanecounty.org to help people in Eugene, Oregon and the surrounding areas. And I'm a University of California guy, but I'm going to say go Ducks to you, Michael.
Thank you all. Really appreciate you being there.
Thank you. This was just terrific. Thank you for being here, everybody. Support foodforlanecounty.org. And with that, we are complete.
Thank you all.
Thank you. Bye.